take permission from my lords, my lordship, just to remind my lords, day before yesterday, your lordship, on account of laches on our part in filing requisites, directed me to deposit 25,000 cost and to list the matter on 18 for the purpose of extension of interim order. Lord, with great respect, I have complied with the order. 25,000 has been deposited, but my matter has not come in the list for the purpose of extending the interim order.
That was fixed to today.
No, it was fixed to 18.
18.
It has not been listed.
No, unless the interim order is extended, they will dispose us.
So you have already deposited.
Yes, my lord, I have.
So bring it in.
Should I give that order so
Yes.
that they will get the number also?
All right.
Great.
Yeah, pardon me. Lord, item 53 may be taken to the because of
Mr. Rotha, it will be in the special notice. It is just coming. It will be intimated.
Great.
But the land question matters, sir. After notice matters, my lord. That has been my lord, for order, I pray, my lord, that has been directed to list it week commence 26th. 16th, my lord, let it be on 23rd orders.
Item pardon my lord. Item 53 may be taken because the urgency. The urgency, the deduction of the salary is getting 2,000. My lord, yesterday I have mentioned before my lord. My lord said we will see, sir. It may be taken after rising of
Item 52. They have filed the counter. I have to file a reply to that effect. Let it come.
Yes, please.
Bank matter, my lord, I have taken consent.
52.
Yes, ma'am.
Mr. Asutosh Panda is
Yes,
there.
this I have taken consent.
Mr. Jyotirmoy Sahu, Land Counsel, appealing for the petitioner, submitted that he has received a counter filed by the opposite party bank and he intends to file the rejoinder affidavit and the matter may be taken off after the ensuing Xmas holidays. He further submits that he has taken the consent of Mr. Asutosh Panda, Land Counsel for the bank, put up this matter in the second week of so and so. Yes.
Yes, obliged.
Item 53 may be taken after rising of this bench.
After rising of the bench.
First,
Pardon to mention, my lord, item number
before
5.
rising, my lord, before rising.
Acha.
53 may.
Modification application file করুন after টাও before করে আপনি yes
On behalf of Madam Jenna Sujatajana, my lord, item 5 can be taken up afterwards.
is there an interim order item number 5 रे
The matter index by it.
all right item number 5 mention is made on behalf of Sujatajana Land Counsel for the petition for urgent this matter. Yeah. Right.
Supplemental list. Item number 1.
Yes, ma'am. May I please, ma'am? My lord, in this case, the petitioner's money has been deposited in some other account. My lord, page number 5. No, page 15. That is the notice. The notice was issued to Krishna Chandra Nandi and Narayan Nandi. They are two brothers.
They are
two brothers, my lord. They are two brothers, but they have died. Page 5. I have given the genealogy.
Why are you standing? No, why are you standing? You mean to say when you stand, we'll take up your matter. We said that please wait. Why don't you say standing? Yes.
My lord. My lord, can make page number 5, my lord. This is the genealogy. I am son of, my lord, my name is Sukanta Kumar Nandi. I am son of late Krishna Chandra Nandi.
No, who is supposed to disburse the amount?
The Gas Authority of India.
Yes. What they have done?
They have deposited that account in some other, that they have released that account, but deposited in some other account. Not some other account. that is in the account of Lakshmipriya Nandi. My lord, the page number 7.
No, this petition has been filed by
Sukanta Kumar Nandi.
So, what is this notice? Who has been issued with the notice?
My lord,
A notice kon Krishna Chandra Nandi kiye?
Krishna Chandra Nandi hochi the ROR holder. He is my father. But another brother is another brother of Krishna Chandra Nandi is Narayan Nandi. His wife, he is dead. His wife is Lakshmipriya Nandi.
Suppose you have received this notice or not? Dated 26/5, kebe ka notice ra?
My lord, that is the notice. Yes, my lord. That is the notice 25/17.
Why have you come here now?
No, I have deposited my account number all total.
Why have you come?
But they have, my lord, page 7.
Sorry.
Page 7, my lord.
Has been filed with a prayer to.
My lord, page 7. In the year of 2023, they have released.
2017. It has already more than 7.5 years has elapsed. In the meantime, no proper explanation has been known. Therefore, we are not inclined to so on the latches on the part of the petitioner to seek appropriate remedy. Therefore, the petition is dismissed. Yes.
My lord, sorry. My lord, may I be
next?
May I be obliged, my lord? My lord, they have released the amount in the year of 2020.
Released it, but it was in the year 2017.
They have released page 7, my lord.
Next, item number 2.
Item 2.
My lord.
Obliged.
My lord, I am for the petitioner. In the year 1983, the legal heir of the lessee, Sushila Beva, sold the property to Vijay Kumar Patnaik. Vijay Chandra Patnaik. Vijay Chandra Patnaik sold the property.
You have,
my lord,
consolidated requisition. You have.
I have submitted, my lord.
Have you received the consolidated requisition? Yes. What is your sorry, that consolidated? Yes. What is your prayer in this petition?
My lord, as for the
which order you want to cause annexure 1?
Yes, my lord.
What is there?
The settlement authorities, they have converted my.
Kindly read the order, sir.
Please read the order.
Awesome.
Annexure 1 you are challenging.
Again.
That is the order passed by the ASO, right?
Again.
So what has been written there?
They have taken my property to government land.
Counsel, you are supposed to read or at least give a English translation copy,
my lord,
of what has been written therein.
My lord, my lord. I will submit.
No, grounds of decision is already there.
Yes.
What is that? Read. That is what my lord is saying. Kindly read. Heard the petitioner.
Headed to the petitioner, had the petitioner examined the documents. On examination of record, it is found that the suit property has been recorded in government khata, and the petitioner has not produced the relevant proper paper justifying the transfer of the suit land of their on their favor. Hence, the case considered merit and disposed. So they have converted my land to.
No. You read right now, and the petitioner has not produced the relevant paper justifying the transfer of the suit land in their favor. Where is that? You filed it.
My lord, I have submitted the papers. I have submitted the paper. Khatian, I have submitted. The OLR record I have submitted. Everything submitted, but on a stereotype mechanized manner, they have converted my land to.
When this order was passed?
Order the past.
This annexure 1 kebe pass ala kona thi?
Again.
Kebe? The objection case re.
Again.
What is the date of this order?
The application copy data.
When you submitted your documents,
my lord,
and what is the proof that these are the documents which you submitted, and in spite of that, the authority has not taken into account your documents and passed this impugned order?
8349 by 12, 2012.
2012.
That is ठीक ଅଛି 2012 ରେ order ଟା କେବେ pass ହେଲା? Case number ହଉଛି 8349 of 2012.
Again.
ଯୋଉ ସେଟା ହଉଛି annexure 1 ରେ pass ହେଇଛି.
Again.
What is the date of the order?
Status nahi.
So, all right, you just now made a submission
Minor.
that all the documents were produced before the authority to justify that your name should be recorded.
Minor.
So, what are the proof that you have produced and which documents you produced?
I have annexed the documents. Those documents.
ଏଠି annex କଲେ ହବ କି ଆମେ କଣ
Minor.
correction କରିଦବୁ
Minor. Minor.
ଯିଏ authority ଆପଣଙ୍କର ନାଁ ଚଢେଇବ ଖାତାରେ ତ ତାଙ୍କ ପାଖରେ produce କରିବେ ନା
Certified
ଏଠି
copy ତାଙ୍କର ସବୁ
କେମିତି
details
ଗୋଟେ ଦେଇଥିବେ what is the mode of submission of the record before the authority କେମିତି ଦେଇଥିଲେ
ମାଇଲର ମୋର ରେଣ୍ଟ
where is that
objection case ଟା ଯେତେବେଳେ initiate ହେଇଥିବ ଆପଣଙ୍କ notice ହେଇଥିବ
ଆଜ୍ଞା
notice ହେଲା ପରେ ଆପଣ ଯାଇଥିବେ
ଆଜ୍ଞା
appear କରିଥିବେ
ଆଜ୍ଞା
ତ documents କରିଥିବେ ଯେ ନାଇଁ ମୋର ଏଇ document ଅଛି ତେଣୁ ଆପଣଙ୍କର objection case
ଆଜ୍ଞା
ମୋ ନାଁରେ ଜମିଟା record କରାଯାଉ
ଆଜ୍ଞା
where is that application which documents is filed
ଗୋଟେ list of
settlement authority
then how you are making a submission that my documents were produced and the authorities have not taken into account my documents and in spite of that it has been recorded as in the government khata.
they have clearly written had the petitioner everything
but no document has been filed that they say that means you have not filed any document.
No,
now you have to substantiate in writ if you have come that this is the application which I had annexed with these documents. Where is that? Otherwise that order has to be presumed to be proper in absence of any material from your side.
That line ta lekha hai na that the petitioner has not produced the relevant paper justifying the transfer of the suit land on their paper ହେଲା ତେଣୁ ଆପଣ କହୁଛନ୍ତି ଏଇ ଯୋଉ ଲାଇନ ଟା ଲେଖିଛନ୍ତି ଅଥରିଟି ଭୁଲ ଲେଖିଛନ୍ତି ମୁଁ ତାଙ୍କ ପାଖରେ ଡକୁମେଣ୍ଟ ପ୍ରଡ୍ୟୁସ କରିଛି ଏହା ତ ଆପଣ ସବମିଶନ so which are those documents which you produce and what is the proof?
I will apply the certified copy. I will submit again.
The writ petition has been filed by the petitioner Snigdharani Samantray with a prayer to pass the order passed by the ASO.
My lord, one submission in the meantime. Adjacent plot, same order was there in Trupti Misra case. They have the order as
adjacent plot ର କଣ ହେଇଥିବ ଆମେ ଜାଣିନୁ ଆପଣଙ୍କ plot ବିଷୟରେ ଆପଣ କୁହନ୍ତୁ
ଆଜ୍ଞା ମୁଁ ସେ ମୋର rent receipt ଆଉ ମୋ ଯୋଉଟା registry
receipt produce the documents we'll see the in objection case number 8349 of 2012 wherein it is mentioned by the ASO that on examination of the documents, on examination of the record, it was found that the suit property has been recorded in the government khata and the petitioner has not produced the relevant papers justifying the transfer of the suit land in her favor. And therefore, the case was considered of no merit and disposed of. The case was considered and disposed of. Accordingly, the case was considered and disposed of. And necessary direction was issued to record so and so in the government khata. The London Council for the petitioner submitted that all the relevant documents have been produced before the concerned authority for recording the name of the petitioner in the ROR, but the authority has ignored the same and the grounds on which the decision has been made under Annexure 1 is not proper and justified. So, when we put a question to the Land Council for the petitioner that is there any proof available with him to show that what are the documents produced before the ASO in the objection case number so and so for recording the name of the petitioner, he seeks some time to take necessary instruction and produce the relevant documents which were filed before the concerned authority. Is this matter? in the week commencing from such and such. Yes. Let's
Item 3.
Item 3, my lord, permitted to withdraw with liberty to file a better and fresher.
the learned counsel for the petitioner files a memo for withdrawal of the writ petition to file a later writ petition. Memo is accepted, the petition is disposed of as withdrawn, giving liberty. Yes.
Obliged, my lord.
Item 4.
Item number 4, your lordship, pray for time.
You are for?
I am for the petitioner.
Last question, my lord, directed to supply the copy of the serve the copy on the writ petition.
Just a minute. Order date, last order is 27/11/2024.
27/11.
Mr. Padi so-and-so is present. Okay. Pointed out from the cost title that the similar matter is pending before this court at the instance of the petitioner in WPC number so-and-so. List this matter. WPC number
1330 पर आसन है तो with
so let a copy of the writ petition along with the enclosures be served on the land and counsel for the opposite party number 2 and 3. 2 and 3 K.
My lord, NHA and land acquisition.
Okay. So they have not served a copy.
I will serve the copy.
The land and counsel for the petitioner submits that he will comply the order dated 27/11/2024 and serve a copy of the writ petition along with enclosures on the land and counsel for the opposite party numbers 2 and 3 by Monday. And he further seeks for an adjournment. Place this matter. Give a date. Yes.
Obliged.
Item 5.
যেটা গলা
5 করে বলা adjourn.
Item 6.
6, my lord, kindly pass over.
Which one?
6.
6 pass over. Like.
Item 7.
Mr. Prabhat Kumar Nayak. Pass over করুন.
Item 8.
Item 8, your lordship, is similar to yesterday's item number 8, your lordship.
Then you would go on item number 8. All right.
Dispose of it, your lordship. This was initially listed before the honorable single judge.
Appropriate. Asked for the order. Same order. Single bench की division bench is
Item 9.
Similar matter is also item 10, your lordship.
10.
Humbly apologize for it.
Okay.
Much obliged.
Item 9.
Mr. Shishir Kumar Swain.
Item 11.
Let's make these tips. My lords, the State Bank is before my lords in a very peculiar situation where after we have conducted the auction sale and sent the sale certificate to the opposite party number 1, that is the sub-registrar Baripada, who has refused or has been unable to transfer the same onto the auction purchaser because a said secured asset in the interregnum has been transferred to some other person during the pendency, my lords. It was a collusive suit filed by the wife of OP number 3, that's the guarantor, as well as the managing director who was a borrower. My lords, after we have taken section 13(2) notice, section 13(4) notice, possession taken, my lords, we moved section 14, collector.
You availed loan to your bank.
My lords, OP number 2, availed loan.
Pradhan Spices Private
right.
Limited.
Number 3 is the managing director.
Just a minute. P2. Who is OP3?
OP number 3 is the managing director.
Of that Pradhan Spices.
Absolutely, Manas. And the land stood in his name. He is also the guarantor in his personal capacity. The disputed land or the secured asset stood in his name.
Okay, then they failed to discharge it, and accordingly 13-4 notice was issued.
Yes,
It
my
was
lords.
put to auction.
Yes,
Who is
my
the successful
My lords,
bidder?
OP number 8, auction purchaser.
OP number 8 is the auction purchaser.
My lords, auction has taken, we had to almost do 10 times auction, and this auction purchase took place only in 18th February 24. But my lords,
No, it's all right, but he is the successful bidder.
Yes, my
That is Shankar Lal Agrawal.
Yes, my lords.
Yes,
OP
then
number
what
8.
happened?
My lords, when we sent the sales certificate to the sub-registrar to get it registered onto his name under Section 89(4) of the Registration Act, at page 22 is the impugned order which we have. My lord, the page 22 of the brief, my lords, annexure 1. My lords, the sub-registrar writes to us with reference to so-and-so that the sale certificate issued in favor of Shankar Lal Agarwal, son of so-and-so, has awarded an area of so-and-so pertaining to plot number, but the data you provided were entered in e-registration database did not reflect this khata, so the property could not be indexed. Further on verification reveals that the land belongs to so-and-so was already transferred to the recorded tenant. My lord, these recorded tenants are OP number 6 and 7, the wife and son of OP number 3. My lords, they have filed a collusive suit behind the bank not being made a party. After all this 13/4/14 notices have been given, possession taken. My lords, they have moved this in on 1st May 2014, and then they have done a compromise, and the suit has been decreed according to this compromise entered between the family members.
Everything was done after it was mortgaged to the bank.
Yes, my lords. After we have taken possession also.
Okay. So this, you mean to say that OP4
OP6 and 7.
OP6 and 7.
OP6 is the wife. OP7 was the minor son then. They filed a collusive suit against OP number 3, saying we had lent him money. So rightfully we own 2/3 of that land. So 2/3 land of the secured asset is now recorded in the name of the OP number 6 and 7. And that is why, my lords, under annexure 4, that has been returned to us.
So suppose such a suit has been filed and it has also been decreed, and
Yes, my
you are a party, necessary party.
Yes, my lord.
So you have, so what is the option available to with you?
My lords, under section 34 of the Surfacy Act, civil court does not have any jurisdiction to entertain any suit or proceeding in any matter which should have been taken to the DRT or the appellate tribunal. Ideally, if they had a cause of action, they should have moved under section 17 under the DRT.
No. When the matter was brought before the civil court, how could the court come to know that the subject matter and issue is in DRT?
It's a fraud played on us.
That is what.
So that is the reason why I was asking you that if fraud has been played on the court, are you remediless? Can you not challenge?
My lords, I have a Supreme Court judgment. My lords, I'll hand it over because we did think about it before moving under 226 and 227 because of the peculiar statute that Surfacy Act is, where they specifically under 1313. My lord, may I just draw your attention to section? It may take up the statute. Section 13, subsection 13 says, no borrower shall, after receipt of notice referred to in subsection 2, transfer by way of sale, lease or otherwise other than ordinary course of his business any of his secured assets referred to in the notice without prior written consent of the secured creditor, my lords. So OP number 3 was obliged to notice us and tell us to be made necessary parties in the suit. My lords, I have a judgment which I want to hand over to my lords so that it's convenient for, because this point has been discussed by the Supreme Court. My lords, just give me 1 minute. I'll just...
So suppose a decree has been passed by the civil court.
Yes, my lords.
Can we entertain a writ to set aside the suit?
My lords.
That a civil court has passed a decree and you say that it is a collusive one and fraud has been committed on this one. So what is the options available to you? Can you challenge that order, and will, in exercise of the power under 226, will set aside a civil court decree?
My lords, because if I submit to the civil court is ousted from jurisdiction as far as the SURFACE Act under section 34.
Can that not issue be reopened if you file appropriate petition before the same court that fraud has been committed and this order is no order in the
My lords, when I approach that court, I am giving it a jurisdiction which it doesn't have. My lords, that's why I'm
No. You can file a petition that it is expressly barred under a special statute. How the court can entertain it?
Look at the judgment.
All right, what is there?
My lords, it's Jagdish Singh versus Hira Lal. Similar thing. My lords, and the delay, because I have already sold. If I go to the civil court again, it will take the same old procedure.
No, you come on this judgment.
Kindly see this
What did it
judgment.
say?
My lords, relevant as para 22, 23, similar matter, my lords. In fact, it was a joint family property. And the Delhi High Court said the civil court can decide the interstate issue. And the Supreme Court said that that's not correct. The scope of 34 came up for consideration.
Which paragraph you want to
My lords,
place?
I am placing page
22.
11, para 22.
22. Please place.
My lord, statutory interest is being created in favor of the secured creditor on secured assets when the secured creditor proposes to proceed against the secured assets under section 13(4) envisages various measures to secure borrower's debt. One of the measures provided by the statute to take possession of the secured asset of the borrower, including the right to transfer by a lease, assignment, or realizing the secured assets. Any person aggrieved by any of the measures referred to in 4 of section 13 has got a statutory right of appeal to the DRT under section 17. The opening portion of 34 clearly states that no civil court shall have jurisdiction to any suit or proceeding in respect of any matter which a DRT or an appellate tribunal is empowered by or under the Securitization Act to determine. The expression respect of any matter referred to in section 34 would take in measures provided under section 13(4) of the Securitization Act. Consequently, if any aggrieved person has got any grievance against any measures taken by the borrower under section 13(4), the remedy open to him is to approach the DRT or the tribunal and not the civil court. Civil court in such has no jurisdiction to entertain any suit or proceedings in respect of these matters which fall into section 4 of section 13 of the SURFACE Act, because these matters fell into the jurisdiction of the DRT. Further, section 35 says Securitization Act overrides other laws if they're inconsistent with the provision of that act, which also takes in section 9 of the CPC as well. My lord, I'm laying emphasis. 23. We are of the view that civil court jurisdiction completely barred so far as the measure taken by the secured creditor under 13(4), which an aggrieved person has a right of appeal before DRT to determine as to whether there has been illegality or in the measures taken. The bank in the instant case has proceeded only against the secured assets of the borrowers on which no rights of response seeks to have crystallized before creating security. In such circumstances, we are the view the High Court was error in holding that only civil court has jurisdiction to examine whether measures taken by. Manoj, here again, it was a joint family.
The factual scenario in this case is that probably that is not in your case. The factual scenario in this case is that the party had filed a civil suit bringing the bank as a party too.
Yes, my lord. Here the auction purchaser.
Yes. So that is not the case here. Here, independent of that, bank being not a party and the court having not been brought with the information that the subject matter of issue is under the challenge before the SURFACE Act.
I'll place a Karnataka High Court judgment where they have given a mandamus saying that the sub-registrar will, when a secured asset is produced, the sub-registrar will put the name of the auction purchaser on a similar situation.
That is different. No, don't shift now. Please come to the civil part, sir.
Yes, ma'am.
Now you are saying that a collusive suit has been filed by the parties behind the back of the bank, and to avoid the rigor of SURFACE Act, is it not? Because the subject matter of the land is a mortgage property.
Yes, ma'am.
So the civil court, when this suit was filed, civil court has not been informed about any of these aspects, and collusively they took the property in their name inter se. Now you came to know
Yes, ma'am.
that a civil suit has been filed and the property involved in the mortgage is a subject matter of the suit. Now, independent of these, judgment are different completely in factual aspect. As far as the bar of civil court is concerned, that is a express provision in the Surface Act, and Section 9 will be a bar for the civil court if there is an express provision.
Yes, ma'am.
So, when the civil court will come to know, unless you go and say that the subject matter of the suit is a matter within the Surface Act and the suit is barred, number one. Number two, by collusive suit, there is a fraud played with the court. So this is something beyond these judgments.
My lords, if I may, with due respect to whatever has fallen from the bench, my lords, Surface Act is a special statute where time is of concern.
Madam,
Yes,
we
my
are
lord.
just putting you a question that if in a suit fraud has been committed on the court and an order has been obtained, is it not the power lies with this very same court to recall that order? Is it necessary? Is it necessary that even to challenge it in the appellate forum? Just examine it.
My lords, I accept, my lords.
So that is exactly what we are asking you, that if a civil court has passed a decree in a collusive suit and fraud has been committed on the court, whether the very court has power to recall that order on the not, on being satisfied that this has been committed.
My lords.
So why are you not, if your answer is yes, approach the appropriate forum.
My lords, the only reason why we have moved this writ petition very, very consciously, my lords.
You are not availing that appropriate forum. You have having that remedy available with you. Question is that how can we entertain this writ petition when it says that it can be entertained only when no efficacious alternative remedy is available.
Yes, my lords. So, my lords, when
and further, my lord was also very correct. Having a decree passed rightly or wrongly by a competent court, now unless that decree is nullified, declared to be not a decree, how this writ court will pass a direction? Only on the basis of that the Surface High Court bars.
Notes that the difficulty the bank is having in such situation is when we go into the civil court, which is specifically barred under the statute, matter the time period. My lords, that is our difficulty. If my lords passes an order.
First of all, you are to approach it. Suppose a question of delay may arise, you may take that
Almost
you are
10
not
years, my
aware,
lords.
right?
Will take.
And if you say that there is likelihood of delay, then after filing that, you can approach this court for expeditious disposal of the suit in the peculiar facts, and all these things are there. But you are not remediless. What we are trying to say that you are not remediless.
My lords,
and the parties are not even, and the parties are not only amenable to the civil side, they are amenable to the criminal side also.
My lords, my learned friend is probably assisting us.
Of the Honorable Supreme Court, that is 1993 Supreme Court page 1139, where the court says, my lord, where the fraud is committed, recall application is to be filed before the same court.
That is what I am saying. That is what we are saying. In the same court.
I accept, my lords, that is the law, but Surface Act stands on a different footing. That is why, my lords, because time is of essence and the bank...
Madam, there is no quarrel in it. There is absolutely no quarrel. That is a statute which expressly bar any matter to be brought in civil court, provided the court comes to know that this is a matter, subject matter under the Surface Act.
The problem we'll face is if such a precedence comes in, then every borrower will...
Madam, what precedence will come is not the question. If a particular matter is to be dealt with in a particular way, it has to be dealt with. You cannot do it.
It's not that universal rule. Every case depends upon the like this case which you cited before us. That the factual is
different. The auction purchase got to know. When the innovativeness of the defaulting borrowers is growing day by day and becoming extremely difficult for
we are conscious of it, but there is no way out.
My lords, then
find out those decisions so that we can.
My lords, we keep it to. I'll do a little research more on this aspect.
The petitioner, State Bank of India, has filed this writ petition with a prayer for setting aside so and so like. The land counsel for the petitioner bank submitted that opposite party number 2, Pradhan Spices Private Limited, availed loan from the bank. What is the date? Have you given that date?
My lords, the loan?
Yes.
It's sometime in 2011, my lords. 1 minute.
And the opposite party number 3, the managing director of the opposite party number 2 company was the guarantor, right? The opposite party number 2 defaulted in making payment of the dues, for which notice under section 13(2) of the Surface Act was served on the borrower oblique guarantor on 9/7/2012. And thereafter, what has happened? Then where have you stated that then 13(4)
Para 7.
In the paragraph.
Para 7. Then on 24/11/2012, the position was taken over under section 13(4) of the Surface Act, read with section rule 8 of the security enforcement rules over the secured asset. And it was put to auction. Where have you stated?
My lord, it was put to auction. My lord,
which paragraph? And that
my
this
lord,
is
it was
the successful the systematic likhna.
My lord, it is systematic. It's in the list of date and events is also there. My lord, yes, my lord, it's there. Page. It's a detailed list of date.
On 18 to 2024, reaction notice was served.
Yes, my lord.
At page
18 to 24.
Page 13.
My lord's page G of the list of date and events.
So okay. 13(4) notice টা গেল না 24/11/2012 তারপরে what is that date about that the auction was held?
My lord's 18 to 24. That's page G of the list of date and events. And
18 to 24.
18/6/2024.
18/6. No,
Yes,
18 to 24 was reaction notice was issued.
And that was a notice and auction took place on.
Next, 16, 17.
On 18 to 2024, reaction notice. Reaction notice dated.
Issued.
Public.
18 to 24.
Notice dated so and so 13 to 2024 was issued.
And finally.
When
6/3/2024.
Auction was carried on successfully on
6/3/2024.
On 6/3/2024, the auction was carried out successfully, and opposite party number 8, namely Sanada
Shankar Agarwal.
Shankar Lal Agrawala was the successful bidder, and thereafter sale certificate was issued.
Yes, my lords.
And on 7/6/2024, the petitioner issued sale certificate along with the position to opposite party number 8 under Rule 9(6) of the Security Interest Enforcement Rules 2002. Stop. Then what happened?
My lords, then we had a lot of correspondence. My lord, finally on 5/7/2024, the OP number 1 returned the sale certificates. But that's on page 8.
No, the sale certificate was issued in favor of opposite party number 8.
8, yes, my
Then
lords.
what you did?
Manoj, then we send the same to the sub-registrar's office.
And
for
this
registration.
the cell certificate was sent for the sub-register for registration
Of cell deed.
of the cell deed. However, on 5/7/2024, the opposite party number 1, district sub-register, intimated.
And that's at page H.
Returned the sale certificate stating that e-registration database
in respect to plot
in respect of plot number 354 didn't reflect
Khata number.
under Khata number 62/176, and therefore the property could not be indexed in the index register, as well as Book 1 under Section 89 of the Indian Registration Act 1908. Further, it revealed that the land was transferred to other recorded tenant, so it could not be indexed in favor of the auction purchaser. When the opposite party number 1 refused to register the secured asset sold by public auction and returned to the petitioner, the petitioner came to, on inquiry, came to know that where is that collusive suit aspect query date chat you have mentioned?
My lords, it's
that on 1/5/2014, opposite party number 6 for self and for Myron son, opposite party number 7 filed a collusive suit for partition bracket like to CS number 13 of 2014 against her husband, that is opposite party number 3, in the Court of London Civil Judge Junior Division Baripada Mayurbhanj for the said property, which had been mortgaged with the bank for the loan taken by the opposite party number 2, for which opposite party number 3 was the guarantor. It is further submission of the land counsel for the bank petitioner that the suit was preliminary decreed in terms of the compromise entered into by the parties on 15/7/2014, and the suit was finally decreed, allotting the properties on the basis of the terms of compromise petition. The London Council further submits that in the said suit, the petitioner bank was not made a party, and therefore the petitioner had no knowledge about the same, and only after the district sub-register communicated with the petitioner that the sale certificate could not be registered in favor of the opposite party number 8, the bank came to know about all these aspects. The Land Council for the petitioner further submits that it is a collusive suit and fraud has been committed on the civil court, and it was suppressed before the civil court that much prior to the institution of such suit, the property in question has been was under mortgage with the bank. The Land Council for the petitioner drew the attention of this court to the provision under section provision ta dekho
One was 1330.
13 bracket with 13. 13. 13.
Yes, my lord, subclause 13.
That is no borrowed funds after the notice by way of swell, so and so, without prior action. Consent to the
Secured credit.
That's no borrower shall, after receipt of the notice referred to in subsection 6, subsection 2, transfer by way of sale, lease or otherwise, bracket, other than the ordinary course of his business, any of his secured assets referred to in the notice without prior written consent of the secured creditor.
Section 34 and 35.
Section 34
and 35.
He has also referred to section 34 of the Surface Act, which says that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the act or under the recovery of debts due to bank and financial institution Act 1993. Any other provisions?
35 also, my lord.
The further case, the section 35 of the Surface Act, which states that this provision of the Surface Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of any such law. If according to the petitioner, fraud has been committed on the which court, that is civil
Junior Division.
On the Court of Civil Judge Junior Division Baripada in CS number 13 of 2024 2014 and order has been obtained, decree has been obtained. When you put a question so and so, that whether the petitioner can approach the very court to recall the order or not, the London Council for the petitioner seeks some time and to examine this aspect, put up this matter after ensuing to the next month's holiday.
See, you have filed an FIR also.
Yes, my lord.
Yes.
We have.
So the person is amenable to criminal as well as civil.
Yes, my lord.
So you have
We are
already
aware.
taken steps.
It is brought as it is brought to our notice that
My lord, 8
the
crores is outstanding, my lord.
petitioner has already filed the first information report before the inspector in charge of Baripada Town Police Station on
7/3/24.
7/3/2024. So whether the FIR has been registered?
Yes, it is registered. It is registered on 27/3/2024.
Nothing much has progressed, my lords, on that.
No, it has been registered.
Yes, my lords.
And the same has been you stationary in
a general diary.
Please, it's a general diary number, my lords. I'll
and
take
a,
instructions.
General diary has been maintained. But according to the petitioner, no first information report has been registered.
My lords, I'll file a short written submission.
The London Council for the petitioner placed the decision of the Honorable Supreme Court in case of Jagdish Singh versus Hirala reported in so and so, SCC reference wherein the Honorable Court has held as follows, quote from paragraph number 22 and 23. However, it appears that factual scenario in the said case and the present case is different. Yeah.
Oh, bless.
Item 12.
May I please, your lordship. In this case, the petition is a civil class lady, my lord. She is the recorded owner of plot number, my lord.
You have submitted a representation by Annexure 1.
Annexure 1 before the
You have
collector.
not got any response on that.
No response, my lord, till that time.
Annexure 1 to be disposed of. Yes.
Time may be.
Yes, yes.
Yes.
Item 13.
Yes, Mr. Pradhan.
13th item is of the matter. Annexure 4 is the similar order.
If similar order has been passed, any correction, just mention it in pencil and give it to us. Usually annexure tadhire jaha agar sei annexure na ulta.
Annexure 3.
Annexure 4.
No, Annexure 3 is the representation.
Yes,
Representation.
Annexure 3.
Annexure 3 is the representation.
4 is the
To the collector, annexure 2 is the representation.
ଆପଣ ପରା କହିଲେ similar matter dispose of ହେଇଛି ବୋଲି ଆପଣଙ୍କ ପାଖରେ order
ସେଇଟା
ଅଛି
correction
sir,
କରି
देखिए
ତାକୁ correction କରି ଦେଇ ଦିଅନ୍ତୁ ଯଦି 3 ଜାଗାରେ 4 ହବ ଗୋଲ ବୁଲେଇ pencil ରେ ଲେଖିକି ଦେଇ ଦିଅନ୍ତୁ pass on ପରେ ହେଲା ଠିକ ଅଛି
3 item sir there.
ନା
these are all
କେତେ ଅଛି?
yes
ଗୁଡାଏ ଅଛି.
Item 14.
May I submit, my lord? I am challenging Annexure 5, page 147 of the petition. My lord, this is a order of Honorable Learned Central Administrative Tribunal Cutoff.
have you given a copy to the Union of India
No, my lord.
Mr. Padi
Yes, my lord.
have you received a copy of this
Advance copy there, sir. Advance copy.
yes
I will take it is listed first time. I will take it.
no have you received a copy we just want to confirm from you that you have
Yes. Advance copy has been given.
okay what is the matter
My lord, I will draw your attention to page number 155 of the petition. My
you are challenging the order passed by the
Order of the Central Tribunal.
Central Administrative Tribunal.
my lord.
Which is that order you are challenging?
Page number
Annexure 5.
Annexure 5, page number 147.
Annexure 5. What was your prayer in that original application?
Original application, my lord, to treat because they belong to the same cadre and same batch.
Please come to the paragraph number 1
My
of
lord.
the order.
Applicant have filed this OA 15/10/2019 seeking to quash the order dated 19/3/2019 and 23/8/2019 with further prayer to extend benefit of regularization and other service from the date of their initial appointment, that is, rendered as reserve training pool in bracket RTP period for the purpose of grant of financial upgradation under TBOP and MSAP scheme in view of the order dated 15/4/2015 passed by CAT Hyderabad bench in OA number 779 and 780 of 2013.
So what are these two orders? 19/3/2019 and 23/8/2019.
Because, my lord, two sets of employees they applied to postal department
Okay.
in different dates because it was a joint application, my lord, before the CAT.
So they sought for relief under this particular scheme that has been torn down by this order, two orders,
My
which
lord,
you.
I will take 2 minutes, my lord. In 1980, there was a advertisement by postal department to recruit on all India basis. They kept some people on reserve post. Merit 1, suppose 100 post, 50 people they kept on reserve post. All reserve people will be getting 2 rupees per hour, 500 rupees per mention. But others, those who are in the merit list A, they will get the full benefits. It was challenged before the Jabalpur bench in 1986. And SLP was there. SLP was rejected. In 1992, Bombay bench, Nagpur bench, they have also given the seminar benefit. All over India except Odisha, that they belong to same cadre, same bench. Again, I will again press, except Odisha zone, all over India, they have got the same benefits according to the advertisement of 1980. May I draw your attention, my
No, what happened? What is the order dated 19/3/2019 which you challenged? Have you annexed it?
Yes, ma'am.
Yes. So what is that order? Please come to that.
Page number 16, my lord.
That is your representation. That is exactly what we are saying. That you submitted your representation for a particular relief and that has been turned down.
Yes, my lord. Page Annexure 1, page 16, my lord.
Please read that order. Order dated Annexure 1.
Your representation on the above matter forwarded to Circle Office Bhubaneswar on dated 31/10/2018. Circle Office by letter number ST/46-20/RTP/2018 dated 13/14/2019 has informed that the judgment of Honorable High Court of AP and Telangana vide interim order dated 10/3/2017 in WP MP number 21403 of 2016 in WP number 174/400/2016 and WP number 21429/2016 in WP number 172/425 of 2016 is case specific and cannot be extended to others. My lord, this was challenged before High Court of Andhra Pradesh. And matter has gone up to Supreme Court, and Honorable Supreme Court in 5/2/2024 rejected the SLP. That is
that means this order is against you.
It is in support of me.
Which one?
That Annexure 1, my lord. The Andhra High Court, Andhra and Telangana High Court order.
No, Annexure 1 is in your favor.
It is not in my favor.
That is what we are saying.
Court order is in my favor.
No, court order was in favor, but the authority said that it is to be applied specifically against those.
My lord.
So you are excluded from that.
My lord.
That is how.
Exactly what we say.
On that basis, I have challenged before Honorable CAT.
Okay, what is the observation of the CAT in the operative part of that order?
Again, my lord, earlier there was a suit, page number 155, my lord. Para 8.
No, come to 9.
Come to the Central Administrative Tribunal's order, which you are challenging now. And come to paragraph number 9, page number 161. Internal page is 15.
My lord.
Yes. Please place it.
My lord, may I submit, my lord, as page 55, 155, para 8. Again, they have referred the matter of OA 534 of 2019, which I challenged, and it is already pending before our Honorable High Court. Two matters are pending, my lord, similar matters. It is 10539 of 2024 and 27840 of 2024, my lord. Same batch, same cadre, my lord, similar order. Good to set this outside. Study go. Dita order. $28,912.
So this matter has got link with that
My lord,
WPC number 10539.
my lord,
In how you say so?
My lord,
It
because-
arises out of that way number 534 of 2019.
my lord. The page 155 para 8. However, after going through the orders of this tribunal dated 7/12/2023 in way number 534 of 2019, we find that the facts and issues involved in the present case were the same and similar to the way number 534 of 2019, wherein this tribunal, after due discussion and deliberation of the entire matter, dismissed the way relevant portion of which are quoted herein below.
Then what has been ordered? Subsequently, what is the just read paragraph number 9.
Paragraph 9, my lord. In the instant case, we also do agree with the stand of the respondent that granting the relief in the present way would tantamount to unsettling the settled matter after a long lapse of time, and that the person who shall be affected in case of relief is granted to an applicant have not been arraigned as party to the litigation. In this connection, this tribunal is remanded by a decision of the Honorable Apex Court, Supertech Limited versus Emerald Court, Honor Resident Welfare Association and others, wherein it has been held that one cannot do indirectly what cannot be do directly. This decision has fullest application to the case in hand because though the applicant did not specifically pray in this way for revision of seniority, same is axiomatic in the event of grant of the relief for regularization of the applicant retrospectively. In view of a detailed analysis made above and going by the earlier order of this tribunal quoted above, we are of the considered view that the applicants were not vigilant but were content to be dormant and close to sit on the fence.
So, the petitioner, so also the order dated 14/11/2024 of the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 260/696 of 2019, in which the prayer made by the petitioners to quash the orders dated 19/3/2019 and 23/8/2019 with a further prayer to extend the benefit of regularization of their service from the date of their initial appointment, that is rendered to reserve trained pool (RTP) ends period for the purpose of grant of financial upgradation under TBOP and MACP scheme has been torn down. The Land and Counsel for the petitioner submitted that while passing the impugned order dated 14/11/2024, the London Tribunal has taken into account the earlier order passed by the tribunal on dated 7/12/2023 in OA number 534 of 2019 and came to hold that the facts and issues involved in the case in hand, so also in the OA number 534 of 2019 were same and similar, and the said OA has been dismissed. And in the operative portion, also the court has taken into account the earlier order passed by the tribunal in OA number 534 of 2019. The Learning Council submits that against the order passed by the Central Administrative Tribunal in OA number 534 of 2019, the applicants of the said OA filed a challenge the order before this court in WPC number 10539 of 2024, and this court by order dated 30/4/2024 issued notice to the opposite party, and therefore this matter is required to be heard along with WPC number 10539 of 2024. The Land Council further submits that similar matter in WPC number 27840 of 2024 has also been directed to be listed along with WPC number 10539 of 2024 by order dated 28/11/2024. Stop. He has produced the order dated 28/11/2024 passed in WPC number 27840 of 2024, which is taken on record. Considering the submission made by the Learning Council for the parties, Lekhidev Upare heard Mr. P.K. Padil and Deputy Solicitor General along with so and so list this matter along with so and so. এটা কেবে রয়েছে সেটা
48
আচ্ছা and 9/12/2024 order এটা দুইটা order pass করে on 20/1/2025 ହେଲା এই কেসରେ দুইটা order produce କରିଛନ୍ତି ହେଲା
20th
କେବେ ରହିଛି ଏଟା 20 ନା 20 ତାରିଖ ରହିଛି ମିଷ୍ଟର
Item 15.
Four matters are identical matters, sir. Yeah, the
identical matter means it is earlier disposed of by this court. Similar matter. Yes.
petition is challenged under your lordship. The order dated 8/8/2022 on the ground of violation of principle of natural justice, your lordship. Lordship may kindly turn to the impugned order issued to page 11, your lordship. On the ground that, my lord, when the award was my lord, the past, the petitioner was not noticed. And your lordship knows, in the Western Odisha, there is a large strike, and due to corona, my lord, he couldn't appear before the court below. That's why the award was passed. After that, my lord, under section 64, the beneficiary is to apply it for reference. But in the present case, my lord, the LAO has referred the case to the authority, your lordship, which is per se illegal, your lordship. Then the authority has confirmed the award passed by the LAO, your lordship, and directed to disburse the amount in favor of the beneficiary's account, your lordship. My only ground is, my lord, I have not been given any opportunity because of the lawyer strike, and due to, my lord, corona, they couldn't appear before the authority.
how you have got interest over this property? Where is the document to that?
ROR is filed.
See, notice was issued to us, Your Lordship.
They are recorded owner.
Yes, Your Lordship.
The award notice was also issued to the petitioners.
That is annexure 1.
Yes, that is notice for the title, Your Lordship.
Okay,
Yes,
then the
Quantum is only the.
Yes,
No, quantum issue is also not there.
The award is passed, but we have not been given an opportunity to file a Section 64 application for enhancement. So
That is what. That is quantum is there.
No.
Yes, yes.
Award notice was issued to the petitioner. Petitioner, through their advocate, enter appearance but did not contest. Ultimately, after 2 years, the reference case was dropped with the observation that perhaps the petitioner have no interest.
And he must have received this amount also.
No,
Not
not also received it. Now the claim of the petitioner is to remand the matter to the collector for reference.
Opportunity to file a 664 application, my lord. Page 11, in the year 2020, my lord, they appeared personally through advocate. And lordship knows, my lord, after that corona in the year 2020, my lord, it continued for 2 years. And due to lawyer strike in Western Odisha, my lord, there was a communication gap between the petitioner and his counsel, your lordship. So only my limited viewers, my lord, we may be given a...
No, according to you, instead that you should have moved to the collector under section 64, the LA has directly referred it to the court.
Yes.
But you appeared and did you file objection to that?
No, that is why I am playing, my lord. Your lordship may give me some opportunity so that we can file an
Opportunity has also
No. Did you challenge that? Though this should have been. So ultimately it was to be referred to that court.
My lord, it should be proper if the petitioner will file the application before the collector.
No, you have mentioned in the read petition your objection before the authority.
That is why my case is that we have not been given a notice.
No, you have appeared as he says, Mr. Naik says.
That is mentioned also. 8/8/2022 order. That is annexure.
Because of that lord strike, my lordship knows, my lord, they didn't appeal.
Number of time I am placing number of.
Submit.
The record is posted today for appearance of the petitioner and to receive the awarded amount with due procedure.
Yes.
As so and so.
But yes,
On perusal of the record, it is found that even after the issuance of summons to the petitioners, they are not appearing to receive the. Just a minute. It further transfer from the record that on 29/12/2020,
they appeared.
They appeared personally to their advocate, but after that they are not taking any steps. As a result of which the record is lingering unnecessarily without any progress. Then he discussed about it and ultimately
discussed the amount. But till then, my lord, in the year 2022, they have not disbursed an amount to the account of the beneficiary. My only limited grievance, my lord, we may be given a chance to file a petition under section 64. Your lordship knows that he appeared on 12/2020 during that corona period, my lord.
Let us see that provision.
Well,
it is
section 64.
When you have given the opportunity and you have not availed it, so.
No, your lordship, my lord, because of the lawyer's latches, my lordship knows, my lord, parties should not suffer.
How long? After 2 years again you are coming?
In the Western
No, that order has been passed long since 2022. And you are coming in 24.
Application, why the delays of
which provision you say?
64.
My lord.
And the petition has not challenged this. They have not brought to this order before that collector. They rather they have filed 64, which is not maintainable. Your lordship may say section 64. Any person, lordship got it, man?
Yes.
Any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objection be to the measurement of the land, amount of compensation, the person to whom it is payable, the rights of rehabilitation, resettlement under chapters 5 and 6, and the apportionment of the compensation among the person interested, provided that the collector shall, within a period of 30 days from the date of receipt of application, make a reference to the appropriate authority.
So this order was passed by the appropriate authority.
That is there. You are not aggrieved on this.
Yes.
Irrespective of the fact there is a provision in 64. How are you prejudiced if the matter has already been referred? You are not prejudiced by that. You are prejudiced only because an opportunity of being heard is not given. That is.
So your lordship may kindly remand the matter so that I can participate in the hearing, my lord, and for enhancement of the compensation.
That is a restriction. provided further that the
Yes.
collector may
Yes.
entertain an application after expiry of the said period within a further period of 1 year if he is satisfied that there was sufficient cause for not filing within a period specified in the first provision.
Reference is to made by the collector when the beneficiary is to file an application under section 64 minor. Thereafter, he has to refer. In the present case, without any application, my humble submission, my lord, he has referred the matter.
How do you say so that it was referred without any application by the
No, that is there. On perusal of the on further perusal of the record, transferred that is special land acquisition officer, Anandpur.
Yes, it is there.
Keonjhar has referred under
From the record, so also the reference letter by 74, 6/7/2020 of the Office of the Special Land Acquisition Officer, Anandpur Barrage Project, Salpada, Keonjhar, it transfers that the petitioner at no point of time after passing of the award have filed any petition before the concerned ALO claiming higher compensation, if any, within the prescribed period as has been mentioned under section 64 of the RFC.
So my humble submission, my lord.
So now the period as
Yes.
Naik is pointed out, suppose you receive the notice under Annexure 1, then you could have filed it that for reference under this
Right, 64.
64. You did not do it, that is
Within 1 year.
This notice is in the year 2022, 39/2022, your lord. And the order is passed thereafter 8/8/2022. My lord, after that, my lord, after receipt of the notice, my lord, he has not filed an objection.
ए रेफरेंस ऑर्डर हला परे annexure 2 annexure 1 रा नोटिस टा गला
Annexure 1 notice receive kariya amount.
After the order is passed on Annexure 2, your lordship,
Right.
notice is issued Annexure 1 to receive the amount. But till then, my lord, they have not disbursed money.
बैंक डिटेल दे द डिस्पर्स करिवे
Your lordship may, it's my lord, the land acquisition matter, lordship knows, my lord. It's a beneficiary legislation to the person who has lost that land, your lordship.
No, which provision you are placing that 1 year?
My lord, 64 proviso provided further that the collector may entertain an application after expiry of the said period within a further period of 1 year if he is satisfied that there was sufficient cause for not filing it within a period specified in the first proviso. First was 30 days.
No, first is 30 days. The beneficiary is to file an application under section 64. The proviso says, my lord, if the collectors are within a period of 30 days, where the
This writ petition has been filed by petitioner Ramnath Sethi with a prayer to set aside the order dated 8/8/2022 passed by the presiding officer LAR and R authority bracketry NT Sambalpur and for remanding the matter to the referral court for redetermination of the compensation, keeping in view section 26 to 30 of 2013 Act, by providing an opportunity of hearing to the petitioner to file his objection claiming higher compensation. It is the contention of the learned counsel for the petitioner that the opposite party number 2, without giving opportunity of hearing to the beneficiary, that is the petitioner, stated that the petitioner had no interest to receive the awarded amount and further said that he having failed to file objection for higher compensation, the order was passed by the opposite party number 3 to deposit the amount of rupees 24,200 in proper head through treasury challan as per section 77 bracketed 2 of 2013 Act. It is further stated that the referral court disposed of the reference suo motu in absence of the present petitioner. And the opposite party number 2 cannot refer the matter to the referral court suo motu without any application being moved by the beneficiaries. The learned counsel for the state, on the other hand, submitted that the impugned order itself indicates that on 29/12/2020, the petitioner appeared to the advocate, but thereafter no steps were taken on behalf of the petitioner. And since the case was lingering without any progress, the opposite presiding officer, कहते हैं opposite party number, LAR authority, opposite party number,
3, Your Lordship.
opposite party number 3 passed the impugned order. Section 64, which deals with subparagraph, with the reference to the authority, says that any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the authority. In the present case, however, it appears that the special land acquisition officer Anandapur Barrage Project Salpada, Keonjhar, has referred the case under section 64 of 2013 Act. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the no notice appear Land counsel for the state accepts notice on behalf of all the opposite party. Extra copies of the writ petition be served on the land counsel for the state. Matter will be listed 4 weeks after, and counter affidavit, if any, be filed in the meantime. Same order in the other
না
case.
তাদের ଟିକେ না অলরেডি তাদের ফ্যাক্টটা ଟିକେ ডিফারেন্স আছে
ଜଣେ ଖାଲି ଲିଗାଲ ମରି ତାଙ୍କ ଲିଗାଲ ମାନେ ପାଟି ଯାଇଛନ୍ତି
ନା କେସ୍ ଅର୍ଡର
ଅରିଜିନାଲ ରେକର୍ଡେଡ ଓନର Your Lordship is WPC 31837
pass କରିବେ 31773 of 2024. এটা କାହିଁ ତାର with ହେଇକି ନା ଏଇଟା ଯଦି ଅଲଗା ଅଲଗା ଅଛି factual aspect.
ଆଚ୍ଛା ଠିକ ଅଛି ଖାଲି ଏଇ 31837 ରେ Your Lordship may see the notice was issued to the original recorded owner. In the meantime, he died, my lord. Thereafter, the legal heirs have finally
change ଅଛି government ଦେଖିන් change କରିବ ହେଲା, but all these matters all right.
Grateful.
Item number 16.
Yes, Mr. Kotua.
Odisha government land settlement matter milot representation is pending milot
Representation disclosure.
Item 17.
Please, Your Lordship. Your Lordship, similar order under Annexure 2, Your Lordship.
No.
Item 18.
On behalf of Mr. Fonda, petition.
Yes,
On behalf of Mr. Fonda, kindly.
after ex masole. A mention is made on behalf of Mr. Manoj Kumar Panda for adjournment. This matter after ensuing ex masole. Yes.
Item 19.
Note of these on details and nature of correction. कौन होगा पूछे? The terms registered in the 7th line of the judgment dated past. So, may kindly be substituted with on the state through the office of the Advocate General. Acha, clear, all right. Will the office note of the registered judicial at flag B in the whatever judgment in the operative portion of the order in paragraph number 13, where it has been mentioned that the registry pay rupees 7,500 to Mrs. Sunanda Viswal and an amicus curiae, the payment for you. Advocate General. The state through the office of the Advocate General shall make the payment as per memo number 4359 dated 7/4/1972 of the Law Department of Government of Odisha. Yes.
Item number 20.
Item 20, my lord.
Lordships. Lordship, in this matter, I am through VC Lordships.
Mr. Naik, receive this order and make the necessary payment to the Land Council.
Can you pick up copy of that order?
Yes,
Item 20.
My Lordship, in this matter, I am through VC Lordship. My Lordship, in this appeal, criminal appeal 599/2013, I have filed IA for interim bail to participate in the marriage of my sister. That is scheduled to on the 3rd of the January, Lordship. The IA
Please.
Have patience, sir. Well, how many appellants are there in this appeal? Only one. Oh, prisoner prisoner's petition at flag A, flag A, has been received. Wherein prayer has been made to engage Mr. Sham Manohar as his counsel. Mr. Manohar has already filed Wakalatnama. The prayer made in the prisoner's petition is accepted. So also the Wakalatnama. The names of other counsel except Mr. Sham Manohar and his associates shall not be reflected in the cause list henceforth. Stop. What is the application?
Lordship, for IA for interim bail to participate in the marriage of my sister.
3221 of
3221.
Yes, Lordship, Lordship, 3221. Lordship, the IA is at flag K. Flag K. Lordship, if you see the IA on page number 9, I have annexed the marriage card, Lordships. Page number 9, Lordships. The marriage card has been annexed. The marriage is scheduled for the 3rd of the January. Some ceremonial function will take place also prior to that, Lordships. And one very important thing which I would like to apply to your Lordships, that in this matter, I was arrested on 22/8/2011. So I am in JC for more than Lordship 13 years.
So that's all right, but now where this authenticity of this wedding
Yes, Lordship.
that is to be taken in.
Yes, Lordship. Yes, Lordship. Yes, Lordships.
Today only I've been served with a copy. I'll take
Just
instruction.
obtain instruction.
Yes, madam.
IN number 3221 of 2024. This is an application for interim bail on the ground of sister's marriage of the petitioner, and marriage invitation card has been annexed in support of the averments taken in the interim application. Land Council for the state submits that he has received
Yes, madam.
the copy of the
Today only.
interim application, and some time may be allowed for taking instruction in this matter. This matter, give a date so that next week you give it.
Lordship, ma'am.
Monday, Lordship,
It is not possible. It will come on Tuesday.
Tuesday is the last working day, so I only humbly pray.
Some time is to be granted. He has to
Yes,
make
Lordship.
today. It is already, and the order is copy is to be handed over to him today in the evening hour.
My
Yes,
Lordship.
tomorrow is the last working day of this week.
Yes, Lordship.
That is the problem. So
Yes.
Yes, next.
I'm obliged, Lordship. I'm deeply obliged.
Item 21.
Vishwar, Sunita Vishwar, no? Yeah. Next, pass over to him.
Item 22.
The appearance through prisoner's petition may be accepted.
You have filed your V number.
My lord.
How many appellants are there?
One.
Prahlad is the one.
Prahlad.
All right. Peruse the prisoner's petition at flag C for engagement of Mr. Biswajit Naik, advocate, as his counsel. The land counsel for the Mr. Naik has already filed Vinama. The prayer made in the prisoner's petition is accepted, so also the Vinama. The name of other counsel apart from Mr. Biswajit Naik and his associates shall not be reflected in the cause list henceforth. Yes, Mr. Naik.
My lord, he is in custody since 27/7/2014, my lord. Custody
27/7/2014.
14, my lord. Lord, see, kindly call for the custody certificate, my lord, because in the COVID period,
ଗୋଟେ ଲେଖି ଦିଅନ୍ତୁ miss case number 13 of
2017, my lord, I am ordering that. My lord, 13 of 2017, my lord, I
miss
have
case
filed
number
two
13 of 2017. The London Council for the appellant does not want to praise this application. This is disposed of as not praised. Then another application is for stay of realization of fine.
My lord, I have filed a separate one, my lord.
That is IN number 258, right?
258.
ସେଟା କଣ କୌଣସି order pass ହେଇନି ଆପଣଙ୍କର stay realization fine?
ନାଇଁ
नहीं अच्छा एटा जो IN number 100 for stay realization of fine एटा allow कर दियन बाकी ଆଉ ଗୋଟେ ରହିଲା IN number ଦିଟା କଣ ଦେଇଛନ୍ତି ଆପଣ?
ସେ 2017 ର ଗୋଟେ bail application pending ଥିଲା
ସେଇଟା ବି withdraw କରନ୍ତୁ.
12 of 2017.
अच्छा miss case number 12 of 2017. This is an application for bail. Land Council for the appellant does not want to press this application. एटा भी dispose of ହେଇଗଲା बाकी जो IN ଗୋଟେ ରହିଲା IN number 259 of 2024. This is an application for bail. The Land Council for the appellant submits that the appellant is in judicial custody since
My lord, 27/7/2014.
27/7/2014. Let the Land Council for the appellant, state, produce the custody certificate, so also obtain instruction about the criminal antecedent, if any, against the petitioner. Matter be listed in the second week of January 2025. Yes.
Item 23.
In item number 23, my lord, last occasion your lordship had directed my lord and friend, my lord, to verify the my lord, address of the present petitioner.
अच्छा ये बिहार handle की?
Yes, my lord. No, the SP Jharsuguda has sent the letter to the Bihar, Aurangabad,
Huh?
12/9/2024, but till yet they are not received the.
So then, if you are you say you are helpless.
No. I have sending another letter also sent. He assured to his he can produce it.
No, one SP of a particular district
My lord.
is sending a letter to another SP
My lord.
of another district of another state. If it is not responding that letter, then the matter lies. Then the chief secretary of the two states should talk with each other that what is to be done. It's not that in such matters your state will remain silent. We are giving you last chance, otherwise you will mention that you are unable to produce any instruction. The learned counsel for the state submits that as per the order dated 26/11/2024, though Superintendent of Police Jharsuguda has made necessary correspondence with Superintendent of Police Aurangabad in the state of Bihar for verification of the address of the petitioner as mentioned in the cause title, but no response has been received from SP Aurangabad, and he seeks some further time so that SP Jharsuguda can pursue the matter, place this matter in the second week of January 2025. Please.
Item 24.
May I please, Your Lordship? Your Lordship, on behalf of Mr. Devasis Panda, Your Lordship. Last occasion, Your Lordship was pleased to allow the appellant free for interim bail for 3 months. Your Lordship, and he duly surrendered. Just we need some time, 7 days time to furnish the surrender certificate.
The learned counsel for the appellant submits that after availing the interim bail period of 3 months as per the order dated 11/9/2024, passed in IN number 2021 of 2024, the appellant number 3, Udayanath Nayak, has already surrendered before the learned trial court, and some time may be granted to produce the surrender certificate. Place this matter in the second week of January 2025. Surrender certificate be produced on the next date. Yes.
Item 25.
Directed to produce the custody certificate. We have written letters. One.
Who is the counsel? Yes, Mr. You have written letter to whom?
To the jail superintendent of different jails. One is Champua and other jails, and also to the superintendent of police to verify with respect to the different appellants, that has not come,
Because when you have written the letter?
Immediately on this last date, when the
last date is 3/12/2024.
On 3/12 only we have issued the notice, and on 5th also it has been issued.
3/12/2024 and 6/12/2024.
5/12.
So today we are on 19th. So
we are following. We are following out over phone. Within 2 days, get it. The only difficulty was expressed was that they are in different jails, so that was the tip.
Thereafter you have they are supposed to just verify the records of kete din etiki lekhibaku tanku dabaku 2 saptah hegalani.
Just one day
available thibo record ei particular accused kete din jail le rahichi etiki dekhikini gote intimation dabaku apanakar 2 saptah lagi jauchi.
That's just one day, Lordship, may kindly will give it.
So in this way, is it not playing with the liberty of a citizen?
I bow down, that's correct, within 2 days, will get it,
The learned counsel for the state submitted that intimation has already been sent to the concerned jail superintendent to obtain the custody certificate of the appellant. However, since no intimation has been received, some further time is required. Put up this matter. Give a date. Yes.
Item 26.
26.
Yeah, please, Your Lordship. My lord, the prisoner petitioner filed sent the wakalatnama. My lord, I am appearing for the appeal.
Wakalatnama in your favor.
My lord,
Where is that?
just today morning I got.
Oh, Aji
I filed in the court.
26.
ତେଣୁ ମୁଁ ମୋର ଏଇଟା ହଉଛି ଗୋଟେ ଲେଟର ଲେଖିଥିଲେ ପରା ଏଠି ଲେଟର ରିସିଭ ହେଇଛି 4/11/2024 ରେ ପ୍ରିଜନର୍ସ ପିଟିସନ। ତେଣୁ ମୁଁ ମୋର କେସ୍ କୁ ଗୋକୁଳାନନ୍ଦ ସାହୁଙ୍କୁ କଣ ନିୟୋଜିତ କରିବାକୁ ଚାହୁଁଛି।
ସେଥିରେ ଜଡିତ
ଚାର୍ଜସିଟ୍ କପି ତାଙ୍କୁ ଦିଆଯାଉ ଦେଖି ଜଣେଇଲି। ତ wakalatnama you have already filed today। ଅଛି ଧରିଛନ୍ତି ମାନେ ରଖିଛନ୍ତି କଣ ତାକୁ ନେଇକି ଯିବେ ଭାରି ଘରକୁ ନା କଣ ଦଉନାହାନ୍ତି। File it.
Yes, ma'am.
The prisoner's petition dated so and so, in which the appellant has prayed for engagement of Mr. Gokulananda Sahu as his advocate. Mr. Sahu has filed the Vinama, which is accepted. The name of Bhakti Sudha Sahu, an amicus curiae, shall not be reflected in the cause list henceforth. Yes.
Copy of paper book, my lord.
You receive in your pen drive, you get it, all those documents. If and paper book is ready, so you receive the paper book. What is necessary? Everything will be available there. Let a copy of the paper book be supplied. Miss Sahu, have you received the copy of the paper book?
Yes, ma'am.
So please return it to since Miss Sahu had already received Bhakti Sudha Sahu has received the paper book. Let him hand over the paper book to Mr. Gokulananda Sahu during course of the day. Yes.
Item 27.
My application for amendment of my writ petition. Initially, an objection was filed there too. But when the matter was taken up, there were certain things which were said which were not reflected in the objection, for which they filed an additional affidavit by way of an objection later on. Now, if your lordships take up that additional affidavit which has been filed, they do not deny that so and so is not the legal heir of the deceased.
No, where is your application?
My application is IA number 13921 of 2020.
You are opposing to the amendment.
Yes.
Okay. So let us go through see that. Where is your IA number 13921 of 2022?
Yes.
Flag it.
Here I have prayed for two things. One is addition of certain parties. Second is, if you kindly take
schedule of amendment.
Yes. Is that page? It begins at page 4. Page 5 essentially are the addition of parties.
3, 4, 5. Yes.
And thereafter, there are certain additional grounds which have been taken addressing the merits of the case. Now, with regard to these grounds, there is nothing said in the objection. With regard to the parties,
what is your objection?
Well, today, initially, I have filed an objection, and later on that some relevant fact it's not been mentioned. That's why I have filed a counter affidavit.
ଅଛି ପୁରା ଫ୍ଲାଗ ସି ରେ ଯୋଉଟା ଅଛି 9/12/2024 ରେ ଯୋଉଟା
13/12 ଗୋଟେ additional affidavit file କର not counter
additional affidavit
ଏଇଟା ତ ଏଇଟା ଅଛି 13/12 ଏଇ 13/12/2024 ଯୋଉଟା ଫାଇଲ କରିଛ
additional
and you have handed over a copy of that same. Okay, what you have stated?
Well, I have stated that the petitioner has ever for addition of some necessary party, and he is claiming that
so far as grounds are concerned, you have no objection.
The grounds are So he has not filed the legal heir and death certificate regarding the claiming that he is the legal heir of the original owner or mortgager of the
Just a minute. Let us again come to that. So why I have stated that these parties to be added on the ground of that. Who are they, Mr. Mukherjee?
They are the legal heirs of the mortgage.
Code election ji?
Para 2.
Para 2.
Correct.
Abdul Hamid Khan was the recorded owner of the land, and on so and so he executed registered sale deed so and so in the name of so and so. Upon due inquiry by the petitioner, it is found that Abdul Hamid is not alive anymore. However, his wife, Rosna Bibi, who is the only legal heir, is still alive, and his presence is necessary. Okay, this is Rosna Bibi.
Yes.
Then about
and then that person, the power of attorney holder of the deceased, he has executed some sale deeds.
Sheikh Afshar.
Yes.
So, according to you, he is also a necessary party.
Absolutely, because they are, if at all the mortgage property has been sold, it has been sold through.
So, what is your objection that you are disputing? Are you disputing that that man is dead?
But I don't have any knowledge
That means
regarding the death or
absence of document is.
Or you say that it is absence of document.
In absence of document, I cannot say that he is dead or alive and he is the only
So,
legal heir.
Mr. Mukherjee, he says that the death certificate and legal heir certificate.
I am the petitioner before the in the section 17 application.
Yeah.
Which is the present writ petition is an outcome of that. So if I fail to produce the necessary parties, he will have an opportunity to say that so and so party is not necessary party, so and so party is a necessary party, or so and so party who is a necessary party has not been added. That will be adjudicated before the tribunal. Those are questions of fact. Nowhere am I required to give legal heir certificate and the death certificate of persons for substituting them.
No. One, if you produce it, what would be the?
It would consume more time. Nothing else. I will have to apply for and obtain the certificate.
If you have not raised any objection, matter is different. But he says that
these are pure afterthoughts. Kindly see the objection. Kindly see the additional affidavit. Para 2.
IN number so and so. This is an application for amendment, and in the schedule of amendment, 3 persons, namely Rosna Bibi, Sheikh Afshar, and Kamru Nisha, has been sought to be implemented as opposite parties number 3, 4, and 5. And apart from that, some paragraphs are sought to be.
May I just make one submission?
Objection has been filed to the interim application, wherein it is stated that what you have stated in your objection.
Para 2.
That so far as addition of Rosna Bibi claiming as only legal heir of Abdul Hamid Khan is concerned, the petitioner has not filed the death and legal heir certificate of Abdul Hamid Khan to prove the claim. That is the main objection.
They only say that that is not within their knowledge, and we have not taken the consent before that.
It was the Abdul Hamid Khan, who is the only original landowner. He has given mortgage to the bank in the year 2010.
No, about the amendment, don't go to the merit about it. That is just so far as the opposite party number 3 objection
death certificate legal.
All right, land counsel for the.
May I just make one submission? May not be necessary. All this may not be. I will. Your lordship may reject that application with regard to addition of party. With regard to the grounds, your lordship may allow and hear the.
That is not facing this interim application so far as addition of parties, and since the petitioner, the opposite party has no objection so far as addition of grounds, the same may be accepted. In view of such submission, the addition of opposite parties number Rosna Bibi, Sheikh Afsar, and Kamrun Nisa stands rejected. So far as the averments taken regarding addition
Para
of
3 onwards of the
para
schedule.
3 onwards is allowed. The same
Para
as
2 onwards. Para 2 onwards. Para 2 onwards.
Para 2 onwards is allowed. Same shall now form the part of the writ petition. The land counsel for the petitioner shall file a consolidated writ petition incorporating so and so, giving copy to the land counsel for the opposite party, Mr. Sahoo, for the bank. Yes.
Item 28.
May I please, Your Lordship? May I please, my Lord? But the main writ petition was filed. My main writ petition was filed where, my Lord, the learned DRAT set aside the interim order that was passed in my favor by the learned DRT, protecting me. And that was
what modification you want?
I'm just clarifying because my friends are placing on merit on the last occasion when they did that. I'm just.
You want modification of the order dated 25/11/2024. Okay. 25/11/2024. Okay.
Your Lordship was pleased to direct
yes,
that the land tribunal will dispose of the case within a period of 2 weeks. Your Lordship directed the interim order to continue till the first date of appearance and to seek for extension there. My only concern for which I have filed this petition is there is a petition for amendment there in the essay before the tribunal. But now because of these 2 weeks, which has already lapsed, and the case was posted to today, my friend Mr. Mishra, who is contesting here, appearing before Your Lordship, he took time today and the case date has not been fixed. Now the tribunal is not.
No, my Lordship, it is wrong submission. The matter has been passed.
That is what I got instruction from the local council. It may be wrong. I make my submission on the basis of instruction. I stand corrected if my friend says I'm wrong. Because I will never say anything which is wrong before the honorable.
just the operative part indicates Land Council for the party submitted that the essay is pending for hearing on 2/12/2024. That was the correct submission or not?
Yes.
Correct submission. Since the parties have already entered appearance before the Land DRT cutter and the matter is to be adjudicated on merit, let the Land DRT decide the matter expeditiously, preferably within a period of 2 weeks. From the date, just a minute. From the date 2 weeks from the date fixed for hearing, all the parties shall appear through so and so, and all of you appeared on 2/12/2024 and shall cooperate with the early disposal. So, if the DRT is facing any problem for early disposal, he has to make a correspondence to this court to extend, because if there's some amendment application has been filed,
in
but
fact,
there is nothing is coming out from the DRT. So why are you filing?
In fact, Your Lordship may pardon me. That was in fact my also advice that the learned DRT has to write and take permission of Your Lordship for extension, not the petitioner. But however, what the DRT is doing, he is not filing application for extension, but trying to complete the case without hearing anything. So that is why I was compelled to file. If Your Lordship observes that,
we'll just dispose of in this way. Like on the IN number an application for modification of the order dated so and so. In the said order, we ask the parties after the parties submitted that the essay is pending for hearing on 2/12/2024. We ask the parties to appear before through their respective counsel on 2/12/2024 and to cooperate for early disposal. All the Land Council submits that the parties have appeared through their respective counsel on 2/12/2024. However, since in that said order dated so and so, we also directed the London DRT to decide the matter expeditiously, preferably within a period of 2 weeks from the date fixed for hearing. It is the contention of Mr. Samir Kumar Misral and senior advocate that since some application is pending with the DRT for what is that application, Mr. Misra?
That is application for amendment to incorporate the that relevant
for amendment to that essay.
My lord.
And that is yet to be adjudicated in view of the order passed by this court, the possibility of the DRT in not taking into account the amendment application and hurriedly disposing of the matter cannot be ruled out. Stop. We make it clear that if any such application is pending, the same is to be adjudicated in accordance with law. We are expressing no opinion on the same. And if the DRT faces any problem in deciding the matter within the stipulated period of time, it is open to the DRT to seek extension of time from this court. Accordingly, this IA is disposed of. Yes.
I am grateful, my lord. I pray for urgent copy, my lord. Grateful, my lord.
Item 29.
Lordship, item number 29 would be small modification. It
Petitioner Pritam Gond alias Pitambar Majhi is inadvertently typed as if Pritam Gond. Acha. And Pitambar Majhi. Pitambar Majhi to ठीक अछि. खाली Pritam Gond जगह ही है Pritam Gond.
Yes.
So देखी कर देगा same shall be read as so and so. है ना? All right. एक form को.
Oh, bless.
Yes, Mr.
Lord,
What is that order? The last order, you say?
The last order is 17th of December 24. 17th, 16th. Item special notice.
16/12/2024.
16/12.
Acha. This matter on being mentioned in the first hour has been listed by way of a special notice. Mr. Praful Kumar Rothal and senior advocate submits that as per the order dated 16/12/2024, he has already deposited cost of rupees 25,000 in the High Court Advocate Welfare Fund. Where is that receipt?
Noting is there in the list itself.
And the receipt has been produced. In view of such deposit, the interim order dated
18th of January 2019. Extended time.
Just a minute. Perhaps first order take
18th of January 2019.
18th of January 2019, passed in IA number 522 of 2018, is extended till next date. Put of this matter. Date fix up reach in a nahin.
Lordship has fixed the date.
The notice guda ka prapon de.
That already fine.
Aja, put of this matter. That jai thamani 4 saptah pare would date de.
That would. Grateful.
Rest of the matter will take up.